Good morning, everyone. Can you hear me okay?
Yes.
Okay. Harriet, are you on the call?
I'm on the call.
Can you hear me okay?
I can hear you as well.
Great. Okay. Thank you all for being here this morning. Let me go ahead if we're all ready to go and we don't have any pre-hearing matters before we get started. We'll go ahead and call the case and talk about how this is going to proceed. All right. I'm going to go ahead and call proceeding number 23D as in dog -0591E. This is the declaratory action commenced by the Colorado Communication and Utilities Alliance and several local governments to determine what entities are responsible for paying for street lighting on certain roads. First of all, if I could go ahead and get appearances. And I think it'd be easiest for me if I could just go across my screen. So first I see, is it Emily? Is it Geraldo? How do you pronounce it?
Yes, I'm Emily Geraldo, and I'm here on behalf of Public Service Company of Colorado, but they are also represented by Stephen Denman, who is not logged in to the Zoom.
Is he going to be joining us?
He is listening in, but he is not going to be at the Zoom.
Okay. All right. Well, hi out there, Mr. Denman.
Mm-hmm.
Okay. Next, I've got on my screen Brandon Dittman.
Good morning, Your Honor. Brandon Dittman of Williams, Wilson, Fellman, Dittman, representing the CCUA and all the local government entities in this case. With me this morning is also Wilson Scarberry, also of Wilson, Williams, Fellman, Dittman.
Okay. And Mr. Scarberry's on the call, you said?
Yes, he's on the Zoom right now.
Okay. I see him now.
Good morning, Your Honor.
Good morning, Mr. Scarberry. Do you want to enter your appearance as well and spell your name for the record?
Yes, Wilson Scarberry, Scarbeary, also appearing on behalf of the Colorado Communications and Utility Alliance.
And the local governments, right? You're representing both
Yes,
all those
correct.
entities.
Okay.
And just to be clear, let me make sure I've got the local governments as I've got it are Town of Morrison, cities of Arvada, Aurora, Centennial, North Glen, and Wheat Ridge. Is that correct? Am I missing anyone?
I believe that's correct.
Okay.
Yeah, that's all of the entities in our coalition. Yeah.
Great. Okay. Glad I've got it accurate. Okay. Then next on my screen, I've got Justin Curry.
Yes. Good morning. My name is Justin Curry. I am, along with Kathy Young, who is also on the call, are from the Colorado Attorney General's Office Transportation Unit, representing the Colorado Department of Transportation in this matter.
Okay. On behalf of CDOT. And then I also see Scott Hofzeitzer. Am I pronouncing that correctly?
Good morning. It's Scott Hofzeitzer.
Hofzeitzer. Okay.
I'm just an observer from CDOT. Kathy Young and Justin Curry are representing CDOT.
Okay. Would you be kind enough to spell your name for the record, Mr. Hofzeitzer?
Sure. Hofzeitzer, Hoftiezer.
Okay. Got it. All right. I don't see anybody else. I think that's everyone, right? If there's anybody present on the call that I didn't call on, please go ahead and let me know right now.
This is Justin Curry on behalf of CDOT, also from our transportation unit. Our paralegal Chastity Rossetti is also listening in on this.
Okay.
She has joined.
Hello, Ms. Rossetti. Okay. Thank you for letting me know, Mr. Curry. Okay. I called for this pre-hearing conference today because I wanted to, first of all, and most importantly, get your perspective on how you want to proceed with this proceeding. I'm not sure, and it's been unclear to me, and I apologize, I've had many other intervening things that have delayed me in getting to this. So it's a little behind the 8 ball here, but I wasn't clear from the brief that I've gotten so far, whether you want to proceed on briefs alone, whether you want oral argument. Are you looking at doing a full evidentiary hearing? As I read the issue, it seemed to me to be primarily a question of statutory interpretation. But, you know, if you think it'll benefit from some evidence or oral argument, I am absolutely willing to consider that. But I wanted to get your perspective on how you wish to proceed. Mr. Dittman, do you want to go first since you're representing the declarants?
Yeah, happy to, Your Honor. So myself and the other parties have briefly kind of discussed, how we think this case should proceed. There is some debate amongst us on how that is. I think you'll soon learn as to how that should happen. But at least from our perspective, I think what we need is we need some limited ability to do some discovery. It's sort of the documentation, in particular in this case, is important. The company Excel has already served CCUA with discovery earlier. We responded to that as a matter of courtesy, even though it was prior to this procedural schedule being put in place. We would like the opportunity to do that as well, because there are some questions that we have concerning documentation from CDOT and Excel, how some of these this issue is being carried out. And so I think that's important for us, is to have some ability to do some discovery. But in terms of the larger question about how this should proceed, I think we generally agree with Your Honor that this case probably lends itself best to a briefing, more so than a full evidentiary hearing. I wouldn't characterize the case as purely being one of statutory interpretation. It's more kind of relevant background to the real issue for us, which is how should we be operating under the company's tariffs when there's a lot of uncertainty about how these lights are being transferred, what tariffs are applicable. Once those lights are transferred, the extent to which we are allowed to maintain those lights, replace those lights, remove those lights. Because I think, we have seen, just from, our perspective, is that there's being a lot of disparate treatment across the Excel service territory and how these lights are being treated. So it really is a question of, what are the parameters of the company's tariffs and the treatment of these interstate lights and how they're being transferred.
Okay. Do you envision this having implications for other local governments as well? Because I mean, once we enter a declaration as to how this should be interpreted, I assume that others will pick up on it and be subject to it as well.
Certainly, Honor. The ones within the Excel service territory. We're very explicit that the commission's jurisdiction here just being over Excel in this case, as the declaratory order was filed. But it will have implications for those other jurisdictions. I will state that there are a number of jurisdictions which have separate agreements with CDOT, which may change, some of the issues here for them, because they have these written agreements which delineate quite explicitly how the streetlights will be paid for and transferred. But for at least from our understanding, and the CCUA represents the vast majority of local governments within the Excel service territory, is that most jurisdictions do not have those agreements in place with the concern of streetlights. And so there is just a lot of, questions that have been longstanding as to how this should operate. And, previous attempts to work this issue out among the municipal league and CDOT and Excel have been unsuccessful, which is why we're here.
Okay, interesting. Well, let me ask you this. When you talk about wanting to do discovery, does that mean just requests for production of documents, or are you also envisioning some interrogatories and or depositions?
No depositions, Your Honor, just purely requests for production, some limited interrogatories consistent with other commission cases. No depositions though.
No depots. Okay. And that would make sense since you indicated you don't think an evidentiary hearing is necessary. So I'm assuming that means you don't really have any witnesses you plan on presenting at all. So
sorry.
Oh, no. And so then no pre-filed testimony either. You don't envision that?
Not at this time. I don't think that makes sense. I mean, this is, understandably a unique kind of proceeding for the commission. And so I think that's kind of the difficulty we have, is how should this operate? Right. But really the issue is, I think, once we have some chance to do some discovery, we could have affidavits even supporting, that these are true and accurate, were served on the company or on CDOT and responded to. using that to inform the, really the decision around what the tariffs mean and what the rules may or may not be under those tariffs.
Okay. That is very helpful, Mr. Dittman. I appreciate it. All right. Ms. Giraldo, do you want to fill me in on what PSCO's response is to all that?
So in conferring with the parties, I think we did have alignment on having a 30-day period for, either side or any party to propound discovery on any of the other parties.
When you say 30-day period from the issuance of any
of the
procedural
procedural
order? Okay.
Okay. Yes, for discovery to take place. And then I believe we were envisioning that the petition could serve as kind of the opening brief, and then the other parties to the case, PSCO and CDOT, would have the opportunity to file response briefs 30 days after the discovery period is closed, just so we have time to consider any responses we receive in discovery. And then there would be an opportunity.
So you said discovery would need to be served within 30 days of the procedural order being issued. How much time do you then need for the discovery itself? So do you want that to close 60 days thereafter? Is that what you're thinking? And then 30 days thereafter again for the petition, for the responsive briefs?
I think we were envisioning that discovery would be completed 30 days after the issuance. So, parties would have to make sure they serve their discovery within enough time to allow it to come back to them within that 30 days if they wanted it to inform their
okay.
And then it would be, you'd have a 30-day period after the close of discovery. So the close of discovery would be, you have to finish serving discovery by that date.
Okay.
And then you'd have 30 days to prepare the responsive briefing. And then there would be another 30 days for the filing of reply briefs from the petitioner. And we were envisioning, similar to Mr. Dittman, that parties could have an affidavit in support of their brief to the extent that there were any facts that are necessary to support legal arguments, because I'm sure you know, some of those will have factual elements, but we are in agreement that there's not a need for pre-filed direct testimony and evidentiary hearing necessarily.
Okay.
But I think ultimately, whether any kind of hearing was desired would be a matter for your discretion after briefing was closed and you reviewed the briefs, and then, determined, Your Honor, whether, there's anything that you think would need to be addressed at a hearing.
Okay.
And Your Honor, may I address the discovery issue kind of briefly from our perspective?
Of course, Mr. Dittman, please go ahead.
Yeah, so I mean, my understanding when we were discussing discovery is that the 30-day period would be, as you originally said, to propound any discovery upon, the other parties. And so in terms of responses, I don't think those should be closed necessarily during the 30-day period, but rather I would recommend, 14 days, which is standard commission practice after being served. So if I file discovery on the 29th day, it would be due 14 days after that, right? The 30-day discovery period. Just because if I think we cut into that 30-day window, you're not really giving me the opportunity to serve more than one round of discovery, right?
And honestly, Mr. Aldo, I have to agree with Mr. Dittman. I think that what you indicated would be really tight. That means discovery would have to go out like tomorrow in order for you to have enough time to turn around.
Oh no, I apologize. That's what I intended to convey. So apologies for any misunderstanding there, but I just meant that you could propound discovery in time to receive responses before your briefing is due. But yes, 10 business days is generally the commission's discovery timing, and we're not suggesting any deviation from that.
Okay, perfect. All right. Anything else, Mr. Aldo?
No, I do believe that there was one matter that between CDOT and Mr. Dittman where there might be some disagreement about jurisdictional briefing. So PSCO doesn't have a position.
And I see Mr. Curry nodding his head. So I was going to have you speak next anyway. So do you want to go ahead, Mr. Curry?
Sure, Your Honor. Would you like me to just give my understanding about discovery first before we go into the separate issue, since we're still on discovery, or?
Yeah, please go ahead. That's fine.
Okay. Yeah. Okay. So CDOT is in alignment with the procedural discussion that just previously occurred. And just so I understand for the record, let's say the order comes out today, later today.
Not going to happen, but okay.
Yeah, hypothetically, okay. Just, okay, yes. Any day, yes. I'm not requesting the order to come out today.
I'll get out as soon as I can, but that's beyond my abilities.
Sure. Okay, let's say it comes out at a time that is the most convenient for you. The day of that order, the parties have 30 days to propound written discovery to the other parties, which could come in the form of multiple sets, provided we are not, we don't have unlimited interrogatories, right?
Okay.
We're correct, right? We're all in agreement on that. There's a specific limit of interrogatories.
That's up to, I mean, the CRCP puts limitations on it.
Yeah.
So I don't know if you want to adhere to those. If you have need for more, I mean, I could change anything. You just got to tell me what you want.
On behalf of CDOT, with respect to the number, I think the presumptive amount under the CRCP is appropriate at this point in time.
Okay.
So assuming the parties stay with this within this limit, and so they can serve multiple rounds of discovery within this 30-day period. However, from each date, right, each party has 14 days from the date to respond. The date that the discovery was propounded. Correct? I'm just trying to understand exactly what we're.
That was my understanding from Mr. Dittman's side and what Mr. Giraldo agreed to. So 14 days post service of discovery, your response to the discovery is due. Mr. Dittman, do you want to weigh in on that?
I believe commission practice is actually 10. I just misspoke the first time, and so I'm happy to stick with commission practice if that's
it is. But again, if you would prefer 14, we could do it. If you want to do 10, 10's great.
10's good with me. So.
All right. Ms. Giraldo, you were nodding, so that's okay with you too?
Yes. And as a matter of clarification, it's 10 business days under the commission's rules. So
yeah, sometimes that equates to 14, but it just depends on the week. Yeah, if you play your Labor Day weekend right, you could, yeah. Okay, so Mr. Curry, is that good with 10 business days to respond to discovery requests? That sounds good to you?
Yes, that's acceptable to see that.
Okay. Go ahead.
Okay, and just to close out at least the discovery, we agree no depots, no pre-filed testimony needed at this point in time.
Okay. Okay, and then Mr. Aldo indicated envisioning that the next round of briefing, which would be any responsive briefs to the petition, would be due 30 days after the discovery has been answered. So at the most, that would be 30 plus 10 business days, right? And that's when that's when the clock starts ticking for your 30 days to file a responsive brief, right?
Sorry, go ahead. I don't want to speak on your behalf, Emily.
Oh, no. Yes, that works from our perspective. And if we want to just build in those 10 business days, if we just want to make it clear, we could just say 45 days from the 30-day deadline to serve discovery or something like that.
I think that's easier to calculate for everybody, and it's less soft, So, yes. So I agree. I think that's just easier for everyone to understand. If we say 45 days post deadline to serve discovery is your deadline to file a responsive brief. Mr. Curry, does that sound good to you?
Yes, with the exception of our plan to address this jurisdictional issue, right? So with I do think that it's appropriate for us to talk about this jurisdictional issue first.
Definitely.
Because what we're talking about is this is the procedural portion of the merits on the petition. However, on behalf of CDOT, we believe that there still remains a subject matter jurisdictional issue with respect to this case. You had asked counsel earlier in this matter if there will be implications for this matter with other local governments, and that was responded in the affirmative. I also want to raise that this also has implications on CDOT as a state agency. And this is where it gets, difficult, because there is a threshold issue here that involves statutory interpretation of the division of authority statute that is outside of the realm of the PUC.
Okay.
Additionally, CDOT, as mentioned in previous briefing, right, CDOT has indicated that this threshold issue is a matter of subject matter jurisdiction that we do not believe is either should be before the PUC's jurisdiction, and that's an issue that needs to be resolved before you can get to this issue associated with the tariffs.
Okay.
And we understood we have raised this issue of subject matter jurisdiction previously as part of our once we were able to intervene. And presently, the PUC has issued an order that did refer this matter to an ALJ, hence the reasoning why we are here today.
Correct.
But we do think that there does need to be some briefing on this subject matter jurisdiction issue before we can get to the merits of the matter, because that does, whether or not this matter, whether or not you conclude that there is subject matter jurisdiction, does have impact on the merits. And we would propose a briefing schedule on this. Again, similar to what was being discussed with respect to the merits in terms of timing, and it would begin after the order following this conference is issued in due course when it is most convenient for you.
Thank you. I guess, as a practical matter, obviously I need briefs on the jurisdictional issue in order to understand your arguments fully. Ideally, from CDOT's perspective, you would want all that briefing done before we ever moved on to the discovery phase, but I don't know that that's necessarily practical for everyone else, and it could delay things even further, which is a concern of mine. So I guess, Mr. Dittman, do you mind weighing in on what the local government's perspective is on briefing the jurisdictional issue?
Yeah, thank you, Your Honor. So we believe that the jurisdictional issue, at least as Mr. Curry envisions it, is moot at this point because the commission has addressed it specifically in their interim decision within paragraphs 24 through 26, where they consider CDOT's jurisdictional issues and soundly rejected, as the petition presented the issue that was a live issue in this case. And I'd also direct the ALJ to Rule 1502 of the commission's rules, which says that CDOT had the ability to challenge that interim decision, either asking for a modification through a motion or preserving that argument for whenever there is the ability to file exceptions or RRR to a commission decision. And so they will have the ability to address their jurisdictional issues again if they so want. But I mean, effectively, this issue has already been briefed by CDOT responding to our petition, raising these jurisdictional issues, us replying to those jurisdictional issues, and the commission rejecting it in the interim decision. So, at least from our perspective, we would like to get on with this case and, get some resolution as to an issue that's currently pending before, many Colorado jurisdictions in the Excel service territory. And there seems to be, further delay for an issue that's already been, at least settled at this point in time.
Okay. Just bear with me for one moment. I tried to open all the pleadings before the hearing, and I was having troubles with Adobe, but now it seems to be working again. So just give me 1 second and let me pull up the commission's original decision on this. So commission issued so they had a decision establishing filing deadlines and then the decision accepting the declaration. So in which one of those was the commission's ruling on the jurisdiction? Because I just wanted to take a quick look at it.
P24-0079I.
Okay. Yes. Okay. And you said it was paragraphs
24 through 26, where the jurisdictional issues are specifically being addressed.
Okay.
Your Honor, if I may.
Yeah, of course, Mr. Curry.
When you pull that order up, I would respectfully ask to draw your specific attention to the final two sentences of paragraph 25, specifically where the commission declined at the early stage in the proceeding to strictly limit the issues as CDOT has requested. And then the commission further expected, to the extent necessary, that the ALJ assigned to this matter will determine which statutory interpretations are required by the commission to clarify public service's ability to transfer payment responsibility, and whether it is appropriate for the commission to opine on such interpretations in the context of this petition. We read that those last two sentences as specifically deferring this statutory interpretation matter, which involves interpretation of non-PUC related statutes, and specifically division of authority, to be something that can be presented in front of the ALJ. Specifically, also, subject matter jurisdiction is a matter that can be raised at any time, even for the first time on appeal, and even by the court. And we do think that this is an admitted threshold issue in that earlier briefing. It is central to the core of this case, and it is step one. We think briefing would be helpful to be presented for the ALJ with respect to the subject matter jurisdiction issue. Additionally, in conformance with the commission's ruling specifically that we're discussing at the moment.
Okay. Yeah, it looks like the commission kind of skated around it. Said, all right, we've got enough jurisdiction to go forward and, you know, and assign it to an ALJ, or refer it to an ALJ, but we're not going to decide the ultimate question of whether there is or is not jurisdiction. Is that a fair interpretation, do you think, of what the commission's order says?
I would disagree with that interpretation, Your Honors. I think, you know, the commission could have said we are declining to rule on jurisdiction at this time, or referring the matter to an ALJ to determine to the extent to which jurisdiction there may be. But instead they said, as you know, Mr. Curry just mentioned, that, you know, there may be statutory interpretations involved here, and we expect the ALJ to undertake those statutory interpretations, declare at that time whether those specific statutory interpretations, you know, are within the commission's jurisdiction, are relevant to this case, not whether the commission has jurisdiction entirely to hear this case, I think, which has been pretty clearly decided as part of the interim decision.
I mean, I don't know that I completely agree with you on that, Mr. Dittman. To me, they touched it, but they didn't really make a definitive decision on it. I think they kind of kicked the can down the road a bit. But I mean, I think that's part of the briefing. You can argue and tell me how you think I should be interpreting the commission's decision. From my perspective, from the way my preference for how this would proceed, and I don't think this is going to be completely what you want to hear, Mr. Curry, but I think it would behoove everyone to go ahead and get going on discovery, but immediately also start working on this jurisdictional question. The briefing on the jurisdiction can come before the briefing of the merits of the petition itself, and would help me. But I don't think it's necessarily a good idea to waylay everything else, waiting to decide that jurisdictional question. I get that it's step one. Jurisdiction was something I dealt with all the time in my previous work, but I also know that sometimes jurisdiction can be tricky. So, briefing is necessary, and you need time to kind of weigh through it and think it through and figure out how you're going to sort it out. And that can take time. And I don't want that time that I'm going to need to figure all that out to keep the discovery from happening. So if I don't know that you're going to agree with me, but my suggestion would be, let's two-track this. We've got the discovery followed by the merits briefing, and on a separate track, the jurisdictional briefing. Mr. Dittman, what do you think of that proposal?
I'm willing to defer to the ALJ's wishes as in terms of the schedule. So if that is the decision, then I can live with that.
Well, I mean, if you've got a different idea, or let me know. I'm open. Like you said, this is an odd proceeding for the commission. So we're kind of we don't have we're not hemmed in too much by the rules or the we can kind of proceed on the way that'll work best for this proceeding. So that's what I'm trying to figure out. So that would be my suggestion. But if you have a different option, let me know. I'm open.
And Your Honor, maybe another option to consider is that, the jurisdictional issues, that CDOT believes exists in this case could just be part of the briefing that is done that includes the merits. It's been done all at one time.
Go ahead, Mr. Curry.
Well, Your Honor, to me, that the merits portion of it might not be necessary and might also not be necessary with respect to CDOT, right? If in fact there is no subject matter jurisdiction over this particular proceeding itself. So I do think that it would be, with respect to what you're presenting, right, in terms of these parallel, right, paths, so to speak, with the jurisdictional briefing while discovery that is being propounded for the merits portion of it, I think is, and then followed by the merits briefing, I think is the most appropriate in this matter, instead of, having this all, end, with one single briefing.
Yeah.
I just do think that it would just be, from our perspective, I think it would just be cleaner that way, right? We have the jurisdictional issue briefed. And then now that we understand once we have an understanding of your order following, this jurisdictional issue, that could also help shape what the briefs would be with respect to the merits. In other words, I do think that they are, while they are separate, they obviously have important relation, and resolving the jurisdictional issue, which again is the threshold matter here, right? Step one will inform how things work for the merits portion, if we get there.
Right. Okay. Mr. Alder, what do you think about addressing? Are you going to, is PSCO even going to weigh in on the jurisdictional question? Obviously, we have jurisdiction over PSCO, so.
It's at this time, PSCO hasn't, developed a position on the jurisdictional question. So I don't think we had any solid plans to submit briefing in that, but reserve the right to, based on future decisions. But it's not something that we're intending to weigh in on at this time. But I do, appreciate the points that are being made about how, often jurisdiction is something that would be addressed before kind of substantively adjudicating the merits of a case. So I definitely appreciate the points that are being made.
Perfect. Thank you, Mr. Alder. I appreciate that. Mr. Curry, let me ask you this. Do you think you're going to need the discovery to do your brief on the merits? Because, to be perfectly frank, that you could start the clock ticking earlier by filing your brief anytime you want to, right? So,
well, so I that's kind of when I was discussing, this issue that, subject matter jurisdiction can be raised at any point in time, right? During the proceedings,
absolutely.
right? Yep. So the reason why we are just asking for a briefing schedule on this was so that the parties are aware of when this briefing is actually going to take place, as opposed to just, firing a brief off somewhere, while this matter starts proceeding.
Right. With that, it comes in and blindsides somebody like, oh no, I didn't know it was coming in right now.
Yeah, right. Just in the interest of being transparent, in the interest of just having something formal, and so everybody is on the same page as to how this matter is going to proceed, we think it would just be helpful for the briefing schedule.
Yeah. I honestly, Mr. Dittman, I'm kind of still inclined to do it the way I had suggested. Let's set up a schedule for the jurisdictional briefing. Also start discovery and set up a separate briefing schedule for the merits. They're different issues. They're separate. Putting it all in one brief isn't necessarily going to save anybody a whole lot of time, to be quite honest, because I think no matter what, you're going to have to do the work and write it up, and I will have to consider jurisdiction before I move on to merits, because, if there isn't jurisdiction, we're not going to go forward. At least not with CDOT. I don't know. We'll see how I'm not quite clear on the whole lay of the land and all the nuances of CDOT's reason for thinking there isn't jurisdiction. So I do need more guidance on that quite a bit. So, okay, Mr. Curry, let me ask you then. So what kind of a briefing schedule do you want? You're going to have the opening volley on the jurisdictional question. do you want to set just a date deadline right now? We can absolutely do that. Today is August 5th.
Yeah, if it's okay with the parties, I think we have, to the extent we get to, we've had a disagreement as to whether or not the briefing was required or the issues of mootness, but I don't think we necessarily had a disagreement on the briefing schedule. I would request at least 30 days before we file our. Well, okay. Well, let me just also raise one more thing real quick. Although this would be our opening volley, it is on. We're happy to take the first opening brief on this issue. Although the burden of subject matter jurisdiction is on the local governments.
Yes,
So,
but you're raising the issue. So.
Yeah, fair enough. Okay, I'm just okay. As long as that's we're familiar. I'm just thinking out loud here. 30 days from today would be if we could
30 days from today.
Or the date that this order comes out following this hearing is fine with you as well. I'm hearing what you're saying with respect to wanting to have this matter proceed. You're right. Well, you're weighing that. So that would be at least our proposal.
Okay. Mr. Dittman, what kind of schedule are you thinking?
Yeah, I think, Your Honor, since Mr. Curry does have the first pin on this, it's not as important to me on when that first day is. However, I would think whatever date it is, it should be from the day of the procedural order, so we're all clear on what day it is rather than today.
I think that's the cleanest. I would say 30 days from the date that the order issues is probably the least complicated. And that would then be, the same day that, I don't want to get this wrong. The same day that the discovery has to be propounded by.
Yeah, so long as that is okay with Mr. Curry. I can't see how, to some extent, the discovery could be relevant to the jurisdictional issues. So I think that's going to show that the streetlights are indeed PSCOs and they're serving our PSCO tariff rates. But if that's okay with Mr. Curry, it's okay with me.
Okay. Mr. Curry, does that work?
Yes.
Yeah, that's good. Okay.
Sorry to interrupt. Yes, that is okay on behalf of CDOT.
Okay, and then generally, commission rules is 14 days post, opening motion. So I guess what kind of time, do you want 14 days post briefs to file responses? You had said, Ms. Geralda said 30 at one point. What do you think? Do you want 30? Do you want 14?
I think
30,
since we've already, to some extent, already gotten into this issue, I think 14 days would be sufficient for us.
Okay. 14 days. And Mr. Curry, do you want to do replies? I will tell you quite honestly, I like them. I think the reply is often where I get the most clarification as to what the issues really are and the most explanation as to what's happening. I know they're not specifically permitted under commission rules. And if I ever get the chance, that's something I might change. But do you want to have the opportunity to do a reply, and how much time do you want to do that?
Yes, Your Honor, we would like to have an opportunity for a reply. 14 days would be our proposal following the response. All
right, Mr. Dittman, are you okay with that? So it would be 30 from the decision till the first brief, and then 14 to respond and 14 to do replies. I'm fine with that. That works for you.
Typically, motions required to do replies, but I think in this case, I will be amenable to that.
I think in this case, it would honestly be extremely helpful to me. To be in another proceeding, I just sua sponte waived the no reply rule and said, look, I don't even know what the party's position is on this. So if you don't reply to this, I'm not going to have any idea what's going on. So I just think replies are useful, especially when you're dealing with a really complicated issue like this. We're not talking about a motion for an extension of time. We're talking about a really complicated issue that would benefit, I think, from even additional clarification. Okay. If I were my notes are a little, I think I got different timelines on this. I just want to make sure I have everything exactly right. So then The the merit response briefs are going to be due 30 days, or what did we say, 45 days post service of discovery to file the responsive briefs. Right? That's what I think that's what we came up with.
I think it was 45 days after the deadline to propound discovery.
Yeah. Does that sound okay, Mr. Dittman?
Yeah, I'm trying to add up the time in my head for the jurisdictional briefing, since that was not on the table when we were discussing that earlier. And so if 30 days, yeah, go ahead.
But the 45 days, I mean, your petition is going to count as the opening brief. I thought that's what you just talked about, right? So it wouldn't hit you, right?
I'm just trying to, in my mind, calculate the time between my response to Mr. Curry's motion, which would be approximately 45 days after, that, and then 40. So there'd be a 30-day period, I guess, in between my motion. So I can live with that.
Is that works? Okay. And then again, like I said, I think a reply on the merits would be helpful as well. So how much time do you think you need post response brief? And this is, Mr. Dittman, you let me know, post those response briefs on the merits to file a reply.
Well, since I'm responding to 2, I think I would like at least 14 days. So
is that enough?
I'll take 30 if you're willing to give it to me. So
I mean, 30 is fine with me. If Mr. Aldo and Mr. Curry want to do that, I don't care. I'd like everyone to have enough time to brief it as thoroughly as you need. Mr. Aldo, what do you think? Do you want to do 30 days post response, merit response briefs to do the reply? Does that work?
Yes, that's agreeable to public service.
Okay. Mr. Curry, what do you think?
No objection. That's agreeable.
Okay. There you go, Mr. Dittman. 30 days post brief to do reply.
Thank you.
Okay. Whew. I'm going to have to do this today just because I'm never going to understand my notes otherwise. Dates all over the place. Okay, so 30 days from service of response, merit response briefs for replies. Okay, so we've got a discovery schedule. We've got a discovery timeline, I should say, a merit briefing schedule timeline, and a jurisdictional briefing timeline. Anything else? Anything else you think you'll need or want in order to get this proceeding moving?
Nothing from the governments, Your Honor. I think, based on the briefing there may be a need for additional, conference, if you will, to figure out what next steps are. But I think for now that sounds appropriate. All
right. Well, maybe what we can do is, at this point, I don't see the need for one, but you guys are, any party is always always welcome to ask for one if you think we need to do another one, or we could even just plan one for a few months out post this briefing. If you decide for example, if you decide you suddenly need oral argument on an issue to clarify things, I'm absolutely willing to consider it if you think that would be beneficial.
I don't think it's necessary at this time, Your Honor. I just, if you would like it in the future, I think, kind of given the uniqueness of this case, just raising it as a possibility.
Okay, that sounds good. All right, Mr. Aldo, anything else?
Nothing further for public service.
Okay, sounds good. Mr. Curry, anything else?
Nothing further on behalf of CDOT. Thank you so much.
All right. Thank you all for being here this morning and being so cooperative. I think we've got this going. I think we've got reasonable timelines set. I promise, Mr. Curry, get this out as soon as I can. Not likely to happen today because I have another meeting this afternoon, but we'll work on it. And again, if you find that we have additional issues, that something that comes up, something else, additional discovery of something that needs to happen, just file a motion. And you're also always welcome to informally email me if there's some just discrete issue you need a quick answer to. Make sure you copy everybody else, obviously, and we'll just try and keep this moving. But I see you're all cooperating together very well, so I think we can get this done without too much trouble. All right. Last chance. Anything else? All right. I think we're in good shape. Thank you all for being here this morning, and have a good rest of your day. Good afternoon, and we are adjourned. Take care.
Thank you.
Thank you.